You're trying to decide whether you need to file a provisional patent application or a full non-provisional utility patent application. I'm going to tell you a secret as to how to figure out which one to file, but first we need to talk about the differences between the two. The two different types of utility patent applications we have in the United States are a non-provisional utility patent application and a provisional patent application. Now, to save myself from having to say and you having to hear me say non-provisional utility patent application a bunch of times, we're just going to call it a patent application, all right? A patent application is filed in order to get a patent. It's going to include a specification, it's going to include drawings, it's going to include claims, an abstract, a title, and all the forms that go along with it to make sure that you have a full patent application submitted. This patent application is what's going to be examined. It typically takes 2 to 3 years in order for it to go through, and ultimately, hopefully, at the end of the process, you end up with a patent. Now, the examination process of a patent application is going to go through whether you've given a sufficient disclosure of the invention, whether it's eligible for patenting, whether it's novel, whether it's not obvious. We're not going to go crazy with those requirements here. If you want to learn more about novelty and prior art and all these things that go into examination, check out this video to learn more about that. Now, it's no secret that a patent application takes a long time to go through. Usually about 2 to 3 years, can be even up to 5 years in some cases where it's a pretty contested application. Why is that? Because the patent application process is set up to be adversarial. Your job is to meet the requirements of the patent law to get a patent, and the patent office's job is to try to not give you a patent. The idea is that if your patent application survives that process, that it comes with a strong presumption that it is valid. Now, the thing is to put together a strong patent application and file it, there's a lot of work that needs to go in at the front end. And it's no secret that patents are not cheap. Now, to file a strong patent application, there's quite a bit of work that needs to happen at the front end. Sometimes up to half of the cost can come into play before you file your patent application. So this can set up a pretty hard decision to make for a startup, because you have to look at the time and the effort and the money that's involved with both filing the application as well as prosecuting it through to get a patent. And when you're in the very earliest stages of your startup, you may have your concept ready, you may have your invention down, but you may still be working on the commercial implementation of it, the thing that's actually going to be valuable, the thing that your competitors are going to try to copy. So what do we do about this when a startup is having to decide whether to commit to a 2 to 3 year process, as well as the time and expense that it takes to get a patent application all the way through? Enter the provisional patent application. The provisional patent application works like a bookmark on your invention with the patent office. Now, why is this important, and why would I bother filing one instead of just waiting to file my non-provisional when I'm ready to file it? Well, it's because of something called priority. And there's two different aspects of priority that we need to think about. We are a first to file patent system, which means that you need to be the first one to file a patent application for your invention with the patent office. That's the first prong of priority. The second one comes in judging when the prior art cutoff date is. Now, we talked a little bit about novelty before as being one of the things that your patent application is examined under. We go into that again a lot more in this video, but we're not going to go to it too far in this video. Ultimately, whether your invention is novel is going to turn on whether there's a single prior art reference out there that discloses each and every element of your invention. Now, when we're talking about non-obviousness, we can combine elements of different references and put them together to come up with your invention. Now, those prior art references are only eligible as prior art from before your priority date. So you see where this date is becoming very important here, because everything that comes into play before that priority date could be prior art against your invention. Everything after that priority date cannot be. So that is why it is important to have an early priority date. Now you could say, well, Josh, I'm not going to have a problem with priority because, well, nobody else has ever done what I'm doing. But the unfortunate part is that your own work can actually count against your ability to get a patent. And that is another reason why that priority date and having an early one. So the provisional patent application, what it does is it gives you that priority date. Now, it's called the provisional patent application, right? So we're applying for something. What are we going to get from our provisional patent application? Do we get a provisional patent? No, don't say that. You're going to sound like you don't know what you're talking about. The misnomer says that a startup can apply for a provisional patent, get one, and then that is a cheaper and more cost-efficient way to get something that says patented. That cannot be further from the truth. A provisional patent application is only going to give you a bookmark on that priority. Now, as I just said a minute ago, that priority is important because that's going to decide when the prior art cutoff date is, and it's also going to decide who got to the patent office first. It's not going to give you a provisional patent. You should never say that you have a provisional patent because chances are the person that you're talking to knows that that doesn't exist, and you'll instantly lose all credibility. So all I get is a priority date. Why would I ever file a provisional patent application? The answer is actually a pretty interesting secret, because a provisional patent application, when done right, doesn't actually lower the overall costs of getting a patent. It actually raises them a little bit, but what it does is it buys you time. And that's the secret. A provisional patent application can be filed early. It doesn't have to include claims. It doesn't need to have formal drawings. It is something that is a little bit less expensive to file initially than filing a non-provisional full utility patent application. So in essence, you're delaying the cost associated with preparing that full non-provisional utility patent application. And you're trading that for the time that you get, that 12-month period, to be able to refine your commercial product to determine what you want to claim in that non-provisional patent application. That delay of the cost and that trading of time is what you need to think about when you're deciding whether you want to file a provisional patent application. If that difference in time is not valuable enough for you to justify the increase in cost of going with the provisional and then the non-provisional, then you shouldn't start with the provisional, you should just go with the non-provisional. If that time trade is valuable to you, in order to have the time to decide what the scope of your claims will be and to firm up the commercial product that you're going to be bringing to market, then a provisional patent application might be a very good idea to start with. And finally, you're also getting the ability to put off deciding whether you want to go through with the full process. Now, a provisional patent application is still going to cost a good chunk of change, but it's going to be less than a full non-provisional utility patent application. So you're able to delay the decision about whether you want to go forward with that entire process until maybe you can market test and you can determine what the commercial value is to getting a patent while still preserving that priority date. So the secret is that the decision about whether to file a regular old patent application or start with a provisional patent application comes down to two main things. First, is your commercial product set up already? Do you have your go-to-market plan in place? If the answer is no to these questions, then starting with a provisional patent application is a great way to bookmark your invention so that any activity that you do after that is not going to work against your ability to get a patent. And then if the delay and the need to put forward the full expense and time and decision to file a full utility patent application is valuable to you, and it's worth a little bit of an increase in cost over the lifetime of that patent application, then a provisional patent application might just be the right place to start. Thanks for hopping on this one. I know it's been a long one. My name's Josh Mertzlufft. I'm an IP attorney. I help space, energy, and tech startups build out their IP portfolios when they're ready to join the big leagues.